Welcome back to the channel. Shocking news has just broken out in the UK. Parliament has just passed an emergency bill aimed directly at Meghan Markle after she was accused of illegally using the titles of Prince and Princess for Archie and Lilibet. This is considered an unprecedented challenge to royal law, and now Meghan is not only facing public outrage, but also the risk of being summoned to court. Let's take a closer look at this dramatic confrontation right now. Do you think Meghan Markle is being treated too harshly and unfairly? If so, please comment 1. If you think the Parliament's actions are reasonable, please comment 0 to let me know. And now enjoy the video and don't forget to leave a subscribe to support the channel. In the dead of night beneath the stained glass dome of Parliament, something unprecedented took place. A vote that had been whispered behind closed doors at Westminster for months. It had been discussed over tea in the private dining rooms of the Conservative Party, debated in the legal corners of the House of Lords, and finally exploded on the floor of the House of Commons. With a wave of the hand and a firm nod from the Prime Minister's bench, a bill had been passed that would rewrite the way modern royalty is viewed. A bill that would have repercussions not just in Britain, but around the world, and all because of Meghan Markle. Yes, it was Meghan who walked down the aisle to join the House of Windsor. It was Meghan who once represented the fresh face of the modern monarchy hailed by some as the future of royal diversity, who was now accused of misappropriating royal titles. Titles not for herself, but for her children. The misappropriation was not just in private family circles, but was also allegedly present on public platforms, legal documents, business ventures, and branding efforts far beyond the United Kingdom. The outrage was not just about what she did, it was about what she challenged centuries of royal structures, sacred traditions, and legacies protected by law. What triggered the crisis was not a single event, but a pot of water that boiled over. Over the past year, more and more critics and analysts have raised eyebrows at the way Meghan and Prince Harry have presented their two children, Archie Harrison and Lilibet Diana, in digital statements, media interviews, school applications, and even promotional materials tied to charitable endeavors. The titles Prince Archie and Princess Lilibet began to appear. Initially, many assumed it was an innocent oversight, a hopeful parental ambition, or perhaps a misunderstanding. This is because the rules around royal styles and titles are often fluid and easily misinterpreted, especially for children born outside the direct line of succession. But insiders say the problem runs much deeper. Parliament has received private legal complaints from watchdog groups, legal scholars, and even individuals with past ties to the royal family, all of whom allege that Meghan has deliberately used royal titles without permission in a way that violates royal protocol and national laws that govern the sovereignty of the nation. With speculation that the Sussexes' children have never been officially granted HRH status, a simmering storm has developed into a full-blown constitutional crisis. The bill known as the Royal Titles Integrity and Protection Act is unlike anything modern Britain has ever seen. The new bill, which has just been passed by the British Parliament, has caused a stir by officially putting Meghan Markle under legal control. According to the text, Meghan has exactly 14 days to remove all unauthorized uses of her royal title from public documents, her personal website, her business papers, and even the school records of her two children, Archie and Lilibet. If she fails to comply, she will face a summons from a UK court. The listed charges include impersonating a member of the royal family, title fraud, and a serious breach of the Royal Titles and Styles Act 1953, a law that has never been used in a court case before. To understand how things have become so tense, we need to look back at the chain of events that has led to this unprecedented confrontation. Meghan, who was once greeted with a fairy tale wedding, now faces criminal charges in her own country. Her journey from royal bride to global sensation is a story of seemingly quiet but provocative moves and public statements that have never pleased the royal family. This is not just a family dispute. It is a legal battle that could change how Britain views royal power and its limits in the 21st century. The story of Meghan and Harry's departure from royal duties has been well documented, but the story of what happened next, the quiet battle over identity titles and legitimacy, is still unfolding. Why do titles matter so much? To most people, especially outside the UK, they may seem purely ceremonial, an outdated relic, a crown and a name. But in the UK and the wider Commonwealth, titles are more than tradition. They are titles established by law conveying constitutional authority, royal inheritance, and access to the mechanisms of the monarchy. Using royal titles without permission isn't just rude, it's a violation of the structure that governs the line of succession itself. According to sources close to Buckingham Palace, the issue began to boil over when Meghan's team allegedly filed paperwork referring to Archie and Lilibet using their royal titles in their official capacity. This wasn't just a birthday card or a children's book. These were forms related to legal guardianship, school admissions tax returns, and even international travel. Government officials who reviewed the files flagged them, noting that the use of prince and princess may not have been officially approved under any royal charter or decree. But what really escalated the situation was the digital footprint. Meghan and Harry's Archie Foundation website, according to many legal observers, contained sections where the children were listed by their titles without any disclaimers or context. Press releases and public statements were seen as leaning on the royal brand while distancing themselves from the crown's responsibilities. Critics called it hypocrisy. Parliament called it fraud. The implications were staggering. If Meghan were found guilty of using these titles without official approval from the Crown, her actions could fall under laws typically used to prosecute individuals who impersonate law enforcement officers or counterfeit military medals. This is more than just a slap on the wrist. If found guilty under the new bill, Meghan Markle could face significant fines and be forced to publicly correct false statements about her royal title. In the most serious scenario, she could even be banned from entering the UK based on national security protocols. This leaves many wondering, how did a seemingly personal dispute escalate into a state matter with direct intervention from Parliament? What do you think about Meghan Markle's decision to give Archie and Lilibet titles without permission, causing the British Parliament to be angry and pass a bill against the Sussexes? If you support the decision of the Parliament, comment number 2, and if you side with Meghan and Harry, comment number 5. Enjoy the video, leave a sub to support the channel, and turn on the notification bell so you don't miss the hottest developments about the British royal family. According to reports from The Times and The Guardian, the story has been brewing since early spring when members of the House of Commons began discussing the Sussexes' unchecked use of their royal titles abroad. Pressure has come from conservative groups, legal scholars, and traditionalists concerned about the dangerous precedent that commercialization of royal titles would set. Conservative MPs, along with a significant portion of the Labour Party, have pushed through the bill called the Protection and Integrity of the Royal Titles Act, which passed its first reading with remarkable speed and bipartisan support. Even skeptics were surprised by the determination and speed with which Parliament moved. Within 72 hours, the bill had passed its third reading in the House of Commons and had the backing of the House of Lords. Chancellor Rishi Sunak signed it into law without delay, making it clear that this was not just a royal matter, but also a matter of national identity and legal sovereignty. Behind the scenes, however, the palace is said to be divided. Sources say King Charles is torn between protecting the reputation of the monarchy and shielding his son's family from public humiliation. Camilla is said to be deeply concerned about what this means for the royal family's image, especially after years of trying to restore her public image. Prince William, on the other hand, is said to have quietly supported the move as a way to strengthen the crown's authority and cut off what he sees as dangerous brand manipulation. As for Harry, his silence has been remarkable. Neither he nor Meghan have issued an official response since the bill was passed. No press releases, no interviews, not even a public denial. Their silence is starting to speak louder than any words. Why aren't they defending the use of the title, and why is Meghan taking legal risks for what many might consider a trivial name on paper? The answer may lie in the lucrative branding power that comes with being a royal, especially in Hollywood. Titles open doors, help land interviews, and bring prestige, admiration, and even sponsorship. For a woman whose life revolves around media deals, children's books, and social engagements, the words prince and princess carry a marketing heft that few other terms can match. But British law is not concerned with American-style branding, and the monarchy especially now seems unwilling to let symbol overwhelm structure. At a time when the monarchy is under intense scrutiny, from rumors about King Charles's health to growing Republican movements allowing the unauthorized use of the title, could disrupt more than just its public image. It could set a legal precedent that could cause chaos for a centuries-old institution. This video takes you behind the scenes of that chaos. We'll take you through the events that sparked the fury of Parliament, the closed-door conversations between lawmakers and palace insiders, and the legal consequences Meghan now faces. You'll see the real-life consequences of treating the royal identity like a brand. By the end, you'll understand not just the law, but the legacy at stake. The first real crack didn't come from a dramatic court filing or an eloquent speech in Parliament. It came quietly via a seemingly innocuous social media update posted on the Archie Foundation's website. Tucked into a message celebrating Lilibet Diana's birthday, a line caught the attention of keen observers. "We are delighted to celebrate Princess Lilibet's special day with community donations made in her honor." The word princess wasn't just a parental term of endearment, it was official, deliberate, and repeated. Within hours, the story had gone viral on royal-watching forums. Was it an honest mistake, a deliberate PR stunt, or a more calculated move? For many in Britain's ruling circles, this was more than just a branding strategy. It was a red line that Meghan Markle had finally crossed. The phrase title fraud began to appear frequently in the media and on social media. Retired civil servants, constitutional scholars, and royal law experts began to comment publicly. At the same time, many former royal aides whispered to the press that Meghan's use of royal titles for her children had been a simmering concern at Buckingham Palace for more than a year. The core of the scandal is emerging the sense that the Sussexes, Harry and Meghan, are trying to redefine the concept of royal on their own terms. Since stepping back from official royal duties in 2020, the couple have never really left the limelight. They have insisted on a desire to retain some of their royal identity, especially the global recognition that comes with it. Although Queen Elizabeth II has allowed them to keep the titles of Duke and Duchess of Sussex, their use of the HRH, His, Her, Royal Highness titles has been quietly suspended, and the pair have been told they will no longer be official representatives of the crown. What followed was a complex dance between respecting the institution and exploiting its presence. Meghan and Harry launched multi-million-dollar content deals, published memoirs and children's books, and spoke at global summits. They carefully cultivated a hybrid identity, no longer working royals, but still close enough to the royal family to attract attention on the world stage. For months, the strategy worked. The Archwell Foundation attracted high-profile donors, and their Netflix documentary series broke records. Invitations to the Met Gala and other elite events quietly trickled in. However, mentions of the titles have since begun to appear more assertively, particularly in digital and legal documents associated with their children. Critics have pointed to charity documents, press releases, and travel documents allegedly filed with both the British and U.S. governments that include the titles Prince Archie and Princess Lilibet. Neither title has ever been officially confirmed by Buckingham Palace through a public statement or new diploma, which is the usual way for titles to be officially bestowed on royal offspring. Yet, on American soil, the Sussexes are being introduced to the world not simply as members of a famous family, but as full-fledged royals. Schools reportedly listed them by title on admissions documents and even tax forms, and legal documents related to California residency reference the titles. What was once subtle became unavoidable. The situation became serious when British reporters discovered a legal document attached to a U.S. trademark application. The document, allegedly filed by a representative of the Archewell organization, referred to Her Royal Highness Princess Lilibet Diana of Sussex in a section related to branding and publishing. For many royal experts, this was irrefutable evidence as it tied the title to commerce. The monarchy, a centuries-old institution defined by tradition, is now being dragged into the realm of market capitalization. Within 48 hours of the leak, a firestorm had erupted in the British Parliament. Some lawmakers who had long criticized the Sussexes' independence from traditional royal duties seized the moment. MPs on both sides of the political aisle began drafting formal complaints to the Prime Minister's office. Legal experts were called in to assess the viability of a law to curb the unauthorized use of royal titles. And in private whispers, rumors began to spread that King Charles himself was deeply uncomfortable with the use of titles he had not formally bestowed. The issue is not just about branding. It goes to the heart of what the monarchy means to the British public. If a former royal can bestow titles on their children outside the authority of the crown, what stops others from doing the same? Could any descendant of a royal simply declare their child a prince or princess? Could someone marry into the family, abandon their duties, and still claim the prestige of royal lineage for their children? For some in Parliament, that possibility represents a constitutional collapse. At the heart of the outrage is the idea that royal titles are not decorative. They are legal representations and symbols of national identity, defining lineage and tying individuals to the very fabric of British governance. Unauthorized use threatens not only the perception of the monarchy, but also the functional integrity of the succession. With King Charles's reign still relatively new and public sentiment towards the crown shifting following the death of Queen Elizabeth, there has been growing pressure on Parliament to assert legal control. The push for action has escalated after a number of legal figures, including a retired High Court judge and a former Solicitor General, published editorials. They argued that unapproved use of the title could constitute a breach of the Royal Titles and Styles Act. That law, originally designed to protect the dignity of royal titles, has not been invoked for decades. But now the legal precedent is being revisited, and lawmakers see an opportunity to make a historic stand. One of the most vocal was MP Geraldine Rowe, who delivered a scathing speech. "We cannot allow individuals who have abandoned the responsibilities of the monarchy to continue to exploit its assets in ways that benefit them financially," she said. "They are diluting what it means to the rest of us," she continued. "Royal titles are not toys. Using them without authority is not only dishonest, it is dangerous." What followed was a wave of bipartisan support. MPs from across the political spectrum issued official statements calling for immediate action. Public petitions began circulating online, some gathering more than 100,000 signatures in a matter of days, calling for a legal framework to limit the indiscriminate use of the title. The media began calling it the Markle Clause, a tongue-in-cheek reference to the proposed new law. And behind the scenes, the palace remained silent, but not idle. Insiders reported a series of exchanges between royal advisors and the Prime Minister's legal team. A senior aide to King Charles is said to have been involved in drafting early versions of the bill. He helped define language that would protect the interests of the monarchy without inviting accusations of political interference. For the first time in decades, the Crown and Parliament appear to be acting in unison. Meanwhile, Meghan's team has remained remarkably silent. There have been no rebuttals, no interviews, no legal filings challenging the allegations. This lack of response has only added to the public perception that something serious is going on behind the scenes. Was Meghan seeking legal advice, preparing to comply, or preparing to fight for Parliament? The lack of cooperation cemented its decision. The time for debate was over. The time for action had arrived. And so, late on a Monday evening, the Royal Titles, Integrity and Protection Act was introduced to the floor of the House of Commons. Within days, it had passed through its early stages, and by the end of the week, it was on the brink of becoming law. The tipping point had arrived. A high-profile couple's attempt to brand themselves through their royal heritage has sparked a legal and political backlash. The consequences extend far beyond Sussex, California. What began as a birthday announcement has ended with Parliament preparing to drag a duchess into court. And for Meghan, the countdown has begun. It's not a normal day in Parliament. The session has been extended by 3 hours to accommodate what officials have called an emergency debate. The subject had not initially appeared on the public agenda. The sudden inclusion of the Royal Title Protection and Integrity Bill sent shockwaves through the media and political establishment. Journalists, accustomed to predictable discussions of tax policy and infrastructure spending, were scrambling to cover it. It was perhaps the most explosive piece of royal-related legislation since the abdication crisis of 1936. The Speaker of the House of Commons entered with a frown on his face, his gavel coming down harder than usual. He called for order as murmurs spread through the chamber. In the front row were MPs with thick files, many of them labeled Royal Secret Affairs. Tension hung in the air. Those familiar with the inner workings of Parliament could tell that this was not a ceremonial move designed to generate headlines. This was a serious matter, and there was a sense in the chamber that something had gone too far. The institution of the monarchy needed to be protected through legislative action. As the formal debate began, the bill's sponsor, Conservative MP Jonathan Aldridge, stood up to speak. A staunch monarchist and former legal advisor to the Home Office, Aldridge's words were carefully chosen but filled with anger. "We are gathered here today not to strip anyone of their dignity, but to preserve the dignity of an institution that defines us as a nation," he said. "The unauthorized use of royal titles, particularly by individuals who have formally retired from service to the crown, cannot go unchecked. This is not about family disputes. This is about the integrity of the nation." A murmur of approval followed. On the opposite bench, Labour MP Saffron Woodgate stood next. Not a known royalist, Woodgate surprised even her colleagues with the seriousness of her tone. "I have disagreed with the monarchy more times than I can count," she said, "but I agree with this bill. What Meghan Markle has done is not merely crossing a cultural boundary. She has crossed a legal boundary. And if we do not act, we are signaling to the world that Britain's most sacred institutions are open to commercial exploitation." The chamber erupted in cheers and applause, briefly interrupting the debate as the chair banged the gavel and called for silence. Outside in the media rooms, broadcasters scrambled to change the night's coverage. BBC analysts whispered into earpieces while Sky News tweaked graphics mid-air. What started as speculation turned into a historic moment. Opposition to the bill was surprisingly thin. A few MPs expressed concern about targeting a former royal who was now a public figure abroad. Liberal Democrat MP Hannah Markham warned of the international backlash that could result from pursuing legal action against a former duchess now living in the U.S. Let us be careful not to make martyrs of those who still want to reconcile with this country, she pleaded. But her words were met with tepid applause, quickly drowned out by a rebuttal from a Scottish National Party MP who reminded the chamber that reconciliation begins with accountability. The frustration was consistent across the party lines. Some lawmakers expressed outrage at the idea that royal identity was being rebranded as what one MP called a lifestyle accessory. He pointedly referred to the use of titles on Netflix promotional material and book launches. Conservative MP Elspeth Troway scoffed, "If we allow this to continue, every celebrity whose cousin is married to a member of the royal family will be able to sell tea towels stamped with the crown." But perhaps the most moving moment of the night came from an unlikely source, veteran MP Sir Clive Finwick. He has been a quiet presence in the House of Commons for more than 30 years. He rarely dabbles in royal matters. His voice trembles as he talks about growing up under Queen Elizabeth and watching the institution evolve through war, scandal, and reform. The monarchy is not perfect, he says. It has stumbled, it has been criticized, it has even been vilified. But it has survived. It has endured because it is anchored by rules. And rules, when broken, are an invitation to chaos. As he sat down, a momentary silence fell over the chamber. Even seasoned commentators admitted they had never seen Parliament unite around a royal issue with such clarity. The bill itself was simple in wording but powerful in its impact. It imposed criminal penalties on individuals who use British royal titles in any official legal or commercial capacity without the approval of Buckingham Palace or the monarch. It created protections for satire and fiction, but made it clear that any real-world use tied to a contract financial gain or public representation would require the approval of the Crown. Crucially, it sets out a 14-day compliance period specifically designed to give Meghan Markle time to withdraw use of the title from all platforms and legal filings before facing a trial. During the debate, MPs read out excerpts from trademark applications allegedly filed by Meghan's legal team in the U.S. They used them as evidence that the unauthorized titles had moved beyond cultural use into the realm of commerce. You don't trademark a child's name unless there's financial value to the name, one MP said, holding up the filing. And you don't assign the prefix princess without authority unless your intention is to create legitimacy. One of the more surprising revelations came when a minister confirmed that the Prime Minister had received a live briefing from Buckingham Palace on the matter in recent weeks. The palace is said to have expressed deep concern about the reputational damage caused by the continued misuse of the title. They also urged Parliament to take whatever action they considered appropriate to protect the monarchy's standing. The revelation that the royal family had been quietly encouraging legislative action was met with gasps of astonishment from the press. While the royal family typically avoids influencing Parliament, their rare intervention underlined the seriousness with which the palace views Meghan's actions. As the debate dragged on into the evening, a consensus emerged. More than a matter of political image or media reaction, this was becoming a referendum on the future of royal power in a modern digital world. If anyone could brand themselves as royal and make money from it, what did titles mean? Just before midnight, the final vote was called. The room, though weary, was buzzing with anticipation. The chair read the motion aloud, and the cheers were louder than anyone had expected. Harry thought about how family traditions are passed down. They're not always written down or spoken aloud. Sometimes they're expressed through the things people leave behind for each other. A small item like this watch can carry more meaning than anything else. It can convey things that words can't express, holding stories that only time can tell. This watch had done just that. It had moved through generations in the family without ever being forgotten, and now it had come to Archie, creating a thread that connects the generations. That royal identity, especially when attached to children who may one day be asked to take their place in history, is not something to negotiate, interpret, or rebrand internationally. Outside, the media frenzy is back on. Headlines blaze across the morning newsstands. Titlegate explodes in House of Commons, one paper proclaimed. Meghan faces legal ultimatum, another screamed. American television networks scrambled to cover the breaking news, spinning it in a variety of ways, from royal repression to constitutional abuse of power. But inside Westminster, the mood was neither celebratory nor vengeful. It was calm, determined, and acutely aware of the historical weight of what had just happened. The heated debate did more than expose the cracks in the Sussexes' story. It forced Britain to confront anew the question it had been avoiding since Harry and Meghan left the palace gates. Can someone really leave the monarchy while still carrying its crown in their pocket? At first glance, the Royal Titles, Integrity and Protection Act seemed straightforward. It's just a few dozen pages of parliamentary language and legal definitions carefully laid out in plain text. But beneath the surface of this legislative document lies one of the most powerful constitutional weapons ever aimed at a member of the royal family. More specifically, at a former royal. The timing, choice of language, and targeted nature of the provisions suggest it was written with meticulous precision, and Meghan Markle is right at the center of this legal barrage. The bill's formal preamble begins, "An act to preserve the dignity and constitutional role of royal titles in the United Kingdom." It also aims to prevent their unauthorized use in any capacity that may mislead the public, create commercial advantage, or misrepresent the official lineage and heritage of the crown. That first sentence isn't just bureaucratic, it's intentional. It sets the tone for a law that isn't meant to address a hypothetical abuse, but rather to intervene in a real ongoing crisis. The bill is divided into 5 sections, each covering a separate area of enforcement. These areas range from digital media to legal documents, and it carefully carves out exceptions for use in satire, parody, and journalism. In short, it's not about policing language. It's about restricting the unauthorized use of titles in any context where they might imply legitimacy, endorsement, or institutional connection. Part 1 of the bill sets out the definitions. Here, royal titles are explicitly defined as any title granted by a degree including Your Highness, Prince, Princess, and any title associated with royal decrees or family affiliation. Importantly, the bill clarifies that the presence of a family connection does not automatically grant the right to use it. This is important because it addresses a gray area that Meghan and Harry often relied on, that their children are entitled by birthright to those titles. Under this law, birthright is not a defense. Only a formal designation by the reigning monarch supported by a document or declaration allows use. Section 2 outlines specific prohibitions. It prohibits the use of royal titles in any public documents, promotional material, or digital platforms unless authorized. This list includes, but is not limited to, nonprofit websites, children's school records, social media bios, interview introductions, podcast recordings, brand profiles, and more. Importantly, the law also prohibits such use across all commercial projects, products, book titles, advertising, and endorsements. Any attempt to monetize a royal title even indirectly is now considered a punishable offense. This section of the bill goes further than expected, targeting proxy representation. This means that a third party, such as an administrator, lawyer, or family member, cannot use titles and official representations unless they have received royal permission. This wording eliminates the possibility of plausible deniability or outsourced branding decisions. It places responsibility on individuals regardless of who disseminates the title. Section 3 deals with enforcement. This is where the bill gets particularly aggressive. When unauthorized use is discovered, the Crown Prosecution Service is empowered to issue a formal infringement notice. This notice requires compliance with the removal of the unauthorized title from all platforms and media within 14 calendar days. The clock starts ticking from the moment the notice is issued. Failure to comply would automatically trigger a summons to appear before a UK High Court judge. The bill also sets out penalties. First-time offenders would be fined up to £250,000 for each instance of misuse of the titles. That means if the titles appeared in 10 different legal or commercial documents, Meghan could theoretically face a total fine of $2.5 million. More importantly, repeated or deliberate breaches could result in criminal charges with penalties including a formal ban. In extreme cases, UK-based assets tied to brand activity could be frozen. One of the more prominent provisions in this section allows British courts to work with international bodies under reciprocal copyright and trademark laws. In simple terms, this means that the government can reach across borders to compel digital platforms based in the US or elsewhere to remove content or material containing unauthorized titles. While enforcement would require cooperation through mutual legal assistance treaties, this mechanism has now been codified in law. The provision is clearly designed to prevent the Sussexes from using US-based protections to shield their branding activities from UK scrutiny. Section 4 deals with exemptions. This is where lawmakers ensure that the law cannot be accused of stifling free speech or creativity. Documentaries, works of fiction, satire, parody, educational content, and journalism are explicitly protected. This means that a Netflix drama about the royal family can refer to Prince Archie as a character. However, a real-life press release from a charity cannot. This distinction is important. It is the intention and representation that matters, not simply the words used. Finally, Section 5 outlines the mechanisms for complaints and review. If someone receives a notice of infringement and believes it is flawed or politically motivated, they can file an objection within a 14-day compliance period. A special judicial panel will be set up to review such cases within 30 days of filing. The panel must include at least one judge with experience in constitutional law and one expert in royal protocol. This measure, while procedural, has been included to ensure the law will stand up to scrutiny in both domestic and international courts. But while the bill is written in legalese, its political and cultural implications cannot be ignored. The bill does not name Meghan Markle, and no specific incident is mentioned. Yet every observer, every MP, and every member of the press understands that this legislation is not a blanket protection. It is a direct response. It is a law born of frustration, of constitutional anxiety. It also stems from a growing belief within the British establishment that the royal identity is not something to be marketed, monetized, or mishandled even by a former duchess. According to senior government officials, the Royal Titles Integrity and Protection Act went through no fewer than 7 internal drafts before it was passed. The drafting process involved extensive consultation with legal experts, constitutional scholars, and even experienced former royals. Fierce debates took place behind closed doors over the scope of the law, weighing how far it should go to protect the institution without provoking an overreaction. Some early drafts proposed revoking the titles altogether, while others wanted to place the use of them under direct control of the Privy Council. Ultimately, a compromise was reached that focused on protecting the public identity and legal clarity of the royal family. However, the provision of a 14-day compliance period caused controversy in legal circles and the media. Government sources said lawmakers wanted to send a strong and clear message to the Sussexes about how seriously they were taking the matter. This isn't about symbolism, it's about implementation, and they want Meghan to know that hesitation will be seen as resistance. Silence, they imply, will speak volumes. What makes the bill all the more explosive is its timing. Introduced so soon after Meghan and Harry's most recent appearance at a high-profile Hollywood event where they were introduced with eye-catching titles, it feels like an act of retaliation. But defenders say it's too little too late. For years, there has been growing unease about the way the Sussexes have balanced royal symbolism with the independence of American-style celebrities. The law, they say, merely restores lines that should never have been blurred. But legal experts warn that enforcement will be challenging. Cross-border enforcement is notoriously slow, and Meghan is no longer a UK resident. While her projects may include links to Britain, most of her operations are based in the US. But the message is clear: the UK will no longer allow royal status to become a global free-for-all. At its core, the bill is not about punishing a former royal. It is about defining where royalty ends and misappropriation begins. For centuries, the British crown has been both a symbolic and a legal institution. Allowing its titles to become a casual branding tool risks diminishing its dignity, undermining public trust, and rewriting history by omission. In essence, the Royal Titles Integrity and Protection Act is a line in the sand. Parliament has made it clear that you cannot benefit from the royal legacy without following royal law. Titles are earned, not assumed, bestowed, not borrowed, and anyone, regardless of reputation, fortune, or family name, who tries to treat them otherwise will face the full force of constitutional justice. The passage of the Royal Titles Integrity and Protection Act sent shockwaves far beyond Westminster. Within hours of its passage, lawyers began parsing every line of the text. Digital media companies across the UK combed through their archives to ensure compliance. Talk shows invited constitutional experts overnight, and quietly behind the glass doors of London law offices, the legal purge of Meghan Markle began to unfold. The language of the bill is clear. Anyone found to be misusing a royal title, even outside the UK, could be held liable. This would happen if the misuse involved British authority, whether through commerce and online presence, or branding involving British citizens or organizations. And Meghan's branding, which is largely tied to her charity work and media projects that involve activities in the UK, would fall squarely within that scope. The first official move came just 3 days after the bill became law. Meghan Markle has been served with a legal notice from the UK's Crown Prosecution Service. The proceedings were not dramatic. There were no police officers present or televised confrontations. Instead, the formal notice was sent via diplomatic mail to Meghan's legal representatives in Los Angeles. But the letter came with a clear deadline. She had just 14 calendar days to fully comply. That meant removing all digital mentions, all press releases, and eliminating any official appearances of Prince Archie and Princess Lilibet in any setting that suggested official royal recognition. The letter also makes clear the serious consequences if Meghan fails to comply within the stipulated time. If the changes are not made, a High Court judge will issue a formal summons for her to appear in London. While she has the right to contest the charges and appeal, failure to appear without a valid reason could trigger additional legal action, making the situation more complicated and unpredictable than ever. These mechanisms include asset searches and public reprimands. Legal analysts were quick to comment. Some said enforcement would be difficult because Meghan is an American citizen residing in the United States. She has no active businesses in the UK beyond a few charities and a small publishing estate. Others disagreed, pointing out that branding, digital platforms, and even charitable work tied to the royal image are still subject to British scrutiny if they affect British citizens or use identifiers associated with the monarchy. But the real shock came when it was revealed that the Crown Prosecution Service had quietly begun collecting documents. More than 20 pieces of evidence were collected, including screenshots from websites, records from the U.S. Patent and Trademark Office, and promotional materials from Archewell-related ventures. A leaked internal memo dated weeks before the bill passed showed that legal teams had been monitoring Meghan's branding efforts for months, perhaps even a year. The document listed a number of potential violations. These included the use of the name Princess Lilibet in charity announcements. The list also includes the inclusion of Prince Archie in sponsorship recognition letters sent to British citizens. It also includes appearances in children's books and educational content marketed under royal-style designations. Even mentions in Meghan's speeches at public events are listed. The memo argues that each case was presented without formal recognition from the British monarch, violating constitutional customs and legal frameworks. In response, Meghan's legal team issued a brief statement to select U.S. media outlets. The Duchess of Sussex has always acted in good faith and in the best interests of her children, the statement read. She has not received any formal communication challenging her use of the titles bestowed at birth under current royal protocols. It was a measured, non-specific denial that resonated emotionally but avoided any direct engagement with the requirements of the new law. In the UK, however, the statement was not well received. MPs accused her of defiance. Commentators said the wording implied Meghan viewed her children's royal status as something inherited and irrevocable, regardless of the Crown's views. This has raised an uncomfortable question. Is Meghan preparing to fight the lawsuit not with compliance but with defiance? Rumors have circulated that Meghan could invoke international protections under U.S. law. Some experts predict she will try to argue that the new UK law violates free speech and parental rights. Others suspect she may try to blame her team, arguing that any misuse of the title was the result of staff oversight, not personal intent. But under the language of the new law, such defenses will carry little weight. Responsibility lies with the individual who benefits from the unauthorized use of the title. In the days that followed, British legal authorities began preparing for a potential high-profile confrontation. Judges were notified and a legal panel was chosen to consider Meghan's appeal. Digital forensics experts began preserving evidence of her use of the title in case Meghan tried to erase her digital traces and deny the violations. What began as a political ruckus now had all the makings of an international legal battle. Amid the legal storm, there was also talk of enforcement. Would Meghan actually be forced to appear in a UK court? And what if she didn't? Would the British government seek to get the U.S. Department of Justice involved? Could they ask for cross-border cooperation through treaties like the UK, Mutual Legal Assistance Treaty? Legal scholars say that while extradition for such an offense is unlikely because it does not qualify as a criminal act under most international protocols, the UK could still take symbolic action. This could include travel restrictions and asset freeze on any UK-related accounts, or an official reprimand that would follow her public image across the Commonwealth. If Meghan tries to visit the UK in the future, such as for a royal event, a funeral, or a charity event, she could be served with paperwork upon entry. Pressure is also starting to mount in unexpected places. Several British charities that have worked with Archie well have received letters from their legal departments advising them to remove or revise any advertising that references the Sussexes' royal titles. A prominent children's literacy organization quietly removed the name Princess Lilibet from its website over legal concerns. In private circles in Los Angeles, the mood is said to have changed. Insiders say Meghan has been taken aback by the speed and severity of the backlash. She expected criticism. She has endured it for years from British tabloids and royal traditionalists. But this is different. This is not commentary, this is prosecution. And now she faces a legal framework designed to target her. Reports from her inner circle suggest that Meghan is carefully weighing her options. Will she fight and turn the incident into an international human rights debate, or will she quietly comply and let the public outcry die down? Each option has consequences. Complying could be seen as an admission of guilt, potentially damaging the image of principled independence the Sussexes have carefully cultivated. On the other hand, defiance could escalate the situation into a transatlantic legal battle, drawing Archie and Lilibet even further into the public eye. Complicating matters further is the question of Prince Harry's role. So far, he has remained silent. But if Meghan decides to fight the charges, she may need him to publicly assert that his children's titles were used with his permission. Doing so, however, would put him in direct conflict with his father, King Charles, potentially irreparably fracturing an already fragile family relationship. And there's another complication. If Meghan faces legal action, any public defense could open the door to cross-examination. Her legal team would be forced to produce documents, emails, internal memos, and branding plans that could reveal how carefully her use of the titles was calculated. If it becomes clear that the titles were deliberately used to build a brand and make money, public sympathy could evaporate even among her supporters in the United States. In Britain, the tone of the press has changed rapidly. Meghan, once portrayed as a woman unfairly excluded from royal life, is now framed as someone trying to rewrite the rules to suit her ambitions. Headlines question whether she has finally gone too far. Commentaries debate whether the royal family should ever be allowed to become a private brand. Even voices who once defended Meghan have begun to express concern. The legal consequences are no longer theoretical. They have begun. The countdown to the 14-day deadline is ringing louder with each passing hour. All eyes are now on one woman. Will Meghan Markle bow to the power of the crown she has relinquished, or will she choose to defy and force a court battle that could redefine what it means to carry on the Windsor legacy? In the quiet rooms of Clarence House, away from the glare of the media and the tabloid headlines, a very different storm is brewing. Unlike the public fury in Parliament or the legal notices in Los Angeles, King Charles's anger is a slow burn. It is an accumulation of slights, broken trusts, and what he sees as a flagrant betrayal of the institution he now leads. This isn't about political theater or brand battles. It's personal. It began with a series of discreet communications between palace aides and Meghan's team. Early last spring, after reports of unauthorized use of the title emerged, a senior advisor to King Charles tried to arrange a private meeting with Meghan's representatives. The goal was simple: to demand an explanation, secure a commitment to stop further abuse, and preserve family unity. Meeting invitations were never returned. Calls went unanswered. Emails were dismissed on the grounds that they were under legal review. Such silence is rare in royal circles. Normally, even the most estranged family member would respond through an official channel, but Meghan's avoidance only added to Charles's frustration. To him, it signaled a disregard not only for the rules of the monarchy, but also for the personal appeals of a father who had always treated her with kindness. In private palace, staff noted that Charles felt emotionally and institutionally hurt. A second, more urgent attempt at outreach came in writing a letter drafted by Sir Christopher Geidt, the king's trusted private secretary. The letter reminded Meghan of her public pledges to respect the crown, referencing her wedding vows to honor and respect the royal family. It outlined specific instances of the title being used, which had been recorded by the palace's legal staff, and demanded that it be withdrawn immediately. There was no response. It was this silence, insiders say, that turned Charles's annoyance into rage. Private sources say that on the morning he learned of the bill's progress through Parliament, he threw a hardback book, a volume of constitutional law, across his office. He then summoned senior staff and told them to ensure no one played with what this family stands for. Charles's private fury was not directed solely at Meghan. Much of his anger was directed at advisors he believed had mishandled the situation. Some senior courtiers are said to have urged caution, warning that legislative action could appear vindictive. Others suggested the matter could be resolved quietly through palace protocol. But Charles, still mourning his mother's legacy and determined to protect his own dynasty, dismissed them. He believed a tough public response was needed to demonstrate that the crown would not be undermined by celebrity influence. In the weeks before the bill was introduced, palace insiders describe a frenetic back and forth. Charles met with his private legal counsel daily, reviewing drafts of parliamentary language and making edits. He consulted constitutional scholars, asking detailed questions about comparative precedents in European monarchies. He even considered the impact on public opinion. He asked advisors to prepare briefing papers on historical public reactions to past royal disputes. At the heart of his private consultations was a single question. The question was, what is the point of being king if your power can be leased to a former member of the royal family? For Charles, the issue was existential. The crown was more than a symbolic head. It represented centuries of continuity, a living thread that had run through wars, reforms, and revolutions. If anyone could borrow its symbol at will, the fundamental premise of the monarchy, its sanctity, would be eroded. But Charles did not reveal these existential reflections publicly. His official statements remained measured and focused on constitutional norms. In a rare brief speech to the audience, he simply noted that the integrity of the crown must be maintained. It was a nod to the fact that the family, through him, had commissioned the law to protect it. Behind closed doors, however, his words were far more strident. In private letters to his eldest son, Prince William, Charles admitted that he felt slighted and disrespected by the Sussexes' actions. William, who had quietly supported the bill in Parliament, responded in a letter of solidarity. "Father, I stand with you. The crown must be protected." The letters were circulated within a small circle of senior royals, cementing the family's united front, at least publicly, against Meghan's use of the title. But not everyone in the royal inner circle agrees with Charles's approach. Some worry that the spectacle of public family conflict will do more harm to the monarchy's image than Meghan's mistake. Senior aides question whether the king is letting personal feelings override constitutional action. One described the atmosphere as tense, somber, and haunted by what-ifs. Another whispered that few had seen Charles so consumed by anger since his mother's funeral a few months ago. The king, however, pressed on. He ordered that no palace events involving Archie or Lilibet could go ahead until the title issue was resolved. He quietly asked press officers to prepare talking points to deal with potential leaks or misinformation from the Sussexes. He even ordered his security team to monitor any public events Meghan and Harry attended in the UK if they chose to test the boundaries of the law. The private fury reached a fever pitch the evening before the bill's final reading in Parliament. According to insiders, Charles dined alone in the royal chapel at Buckingham Palace. He went over the final draft line by line. His face, seen by only a handful of witnesses, was stern, determined, and unwavering. He knew that once the bill was passed, there would be no turning back. At 11:47 p.m., the king sent a brief coded message to the Prime Minister: proceed as agreed. It was the green light Parliament needed to complete the bill. Months of private rage, fueled by silence and perceived betrayal, was transformed into decisive legislative action that would define the early years of Charles's reign. Still, Charles felt burdened by the personal cost. He knew the bill would further alienate Meghan and put her and Harry on deeper conflict with the monarchy. He understood that some would see it as heavy-handed, even vindictive. But in his mind, there was a larger obligation to history, to the institution, that he would one day pass on to his grandchildren. He also had an obligation to the millions of people who still looked to the crown as a symbol of stability and service. After the bill passed, Charles briefly retreated to Balmoral in Scotland, seeking peace in the Highlands. There, amid the heather-covered hills, he reflected on the extraordinary steps he had taken. He considered the precedent he had set the Act of Parliament, specifically targeting a member of his own family, and he wondered, as kings before him had, whether the weight of the crown would ever allow for a simple pardon. But for now, there would be no pardon. The next move was Meghan's, and Charles would be watching closely. His private rage became public law, and in the transformation, he believed he had saved the monarchy title by title. Within hours of the Crown Prosecution Service's compliance announcement, Meghan Markle's team was in crisis mode. Until then, their public messages had been carefully calibrated to balance sympathy and strength. They had portrayed Meghan as a modern royal navigating ancient traditions, a woman who had endured relentless media scrutiny and institutional bias. But now, with a binding legal deadline and the threat of a subpoena hanging over their heads, the Sussexes faced a dilemma. On the morning of the announcement in Los Angeles, Meghan's chief communications strategist convened a virtual meeting with her legal team brand managers and a small group of trusted advisors. The agenda was clear: how to respond in a way that minimized legal risk, maintained public support, and preserved the couple's carefully crafted narrative of principled independence. The instructions were immediate: acknowledge the letter without admitting wrongdoing, express a willingness to cooperate, and emphasize Meghan's good faith belief that her children's titles were bestowed upon them at birth. But executing that instruction proved tricky. A simple press release risks being perceived as a cliché. A live interview might open the door to hostile questions. Instead, the team developed a three-pronged approach. The approach focused on an open letter-controlled social media messaging and selected sympathetic media placements. First was the open letter, which was posted on Archewell's website under the headline, "A Mother's Duty." The letter was addressed directly to our friends and supporters around the world. In carefully measured language, Meghan wrote that she had always sought to honor the traditions and dignity of the crown while forging a new path as a mother and supporter of causes she loved. She expressed surprise at the legal notice, describing it as a misunderstanding of matters that had been decided at the time of her children's birth. She emphasized her children's rights as descendants of the crown and her belief that their titles were granted in accordance with custom and precedent. Crucially, the letter did not provide any formal legal recognition. Meghan wrote that she was consulting with legal counsel to ensure full compliance while maintaining my responsibility as a mother to protect the identities of my children. The wording is meant to signal respect without conceding empathy without surrender. It also serves to buy time. By committing to consultation, Meghan can argue that any unapproved use is due to a lack of understanding rather than deliberate fraud. To support the open letter, the Sussexes' social media channels have posted a series of curated images. There are family photos from happier times, behind-the-scenes shots of Meghan volunteering with children's charities, and archived images of royal births from previous generations. The captions that accompany each image reinforce the theme of inheritance generation after generation, a legacy carried on a mother's promise. The posts focused on visual storytelling designed to generate viral sympathy and drown out headlines about title fraud. Meanwhile, Meghan's legal team prepared a targeted communications strategy. They arranged for two sympathetic media outlets, a leading U.S. women's magazine and a British digital platform known for its progressive commentary, to publish in-depth articles that would provide a deeper look at Meghan's perspective. Each article featured interview excerpts from a carefully selected journalist. The excerpts portrayed Meghan as respectful of the monarchy, but hurt by what she saw as a punitive legal response. One such article included the words, "I left the institution, but the institution never left me or my children." The intention was to frame the story as a confrontation between Meghan's heart and the cold machinery of the crown. Behind the scenes, however, tensions were running high. Some advisors warned that the inheritance argument was legally weak under the new law, which makes it clear that birth alone does not confer the right to use a title. Others warned that framing the issue as a private family matter risked alienating Parliament, whose support the Sussexes still need for any future negotiations over the role of their children. As the 14-day deadline approaches, Meghan faces mounting pressure. Every day brings new headlines parsing her open letter, speculating whether she will comply or defy it. Commentators debate whether the public will side with the underdog or an institution that prides itself on rules and traditions. Polling data leaked to the press shows a divided public. A significant portion of Americans support Meghan unconditionally, while a large portion of Britons back Parliament's tough stance. The most dramatic developments come on day 10 of the deadline. On that day, an excerpt from Meghan's upcoming memoir was published in a prestigious magazine. In it, she describes her wedding day as the moment I became part of something bigger than myself, bound by vows to serve a family and a country. She writes of the joy of holding her newborn daughter, believing that the crown would welcome her children as fully as it had welcomed her. The passage ends with the poignant line, "I still believe in that promise." The memoir excerpt was meant to reinforce Meghan's sincerity, but it also had unintended consequences. Legal experts point out that her own words acknowledging her oath to respect the monarchy could be used as evidence. This would show that she knew the rules of the crown and deliberately chose to use royal titles despite any doubts. Crown lawyers have quietly marked that passage in their internal case files. With just 2 days left until the deadline, the Sussexes face a crossroads. Should they issue a formal compliance notice, removing all references to royal titles from their platforms, or should they take a bolder approach and challenge the constitutionality of the law? One camp argued for immediate compliance, arguing that Meghan's public image could recover more quickly after an act of contrition. Another camp feared that compliance would be seen as a legal failure, undermining years of branding focused on autonomy and empowerment. Meghan eventually issued a second, more substantive statement on day 12. It began with an admission. In light of the recently enacted Protection and Integrity of Royal Titles Act, I have instructed my team to update all public documents and references to my children's titles. She stated her intention to complete the process within the next 48 hours, essentially extending the deadline by asking for leniency. She also noted her desire to work with palace officials to establish clear guidelines going forward. The announcement stunned many observers. It signaled that Meghan was willing to comply, but only on her own terms. She framed the move as a gesture of goodwill while still emphasizing her belief that the law was too broad and potentially harmful to her family. Critics called it a half measure and hypocritical. Supporters hailed it as a graceful compromise. In London, the Crown Prosecution Service (CPS) examined the statement. Officials noted that Meghan's pledge covered digital content and advertising, but did not address third-party use such as school records, trademark records, or documents from charity partners. The notice also lacked specific evidence that the removal had been completed. On day 14, the CPS issued a follow-up request which required detailed written evidence of compliance by the end of the day. Meghan's team raced to meet the request. By midnight, they had presented a list of more than 150 URLs, documents, and media assets that had had their title references removed. They also provided screenshots showing the before and after versions. They also provided letters from several UK-based charities confirming that they had updated their documents accordingly. Some prominent platforms, such as a major online bookstore, issued public corrections, removing the name Princess Lilibet from book descriptions. That night, the Sussexes breathed a sigh of relief. Meghan had complied, at least in the narrow sense the CPS meant, but the underlying conflict remained unresolved. While Parliament acknowledged compliance, it made it clear that it would remain vigilant. The new law has put Meghan Markle under intense scrutiny with the risk of being reinvestigated if she repeats the offense. After receiving formal notice, she has 14 days to remove all royal references from public platforms. Beneath the facade of compliance, Meghan's emotional media style clashes with Britain's strict legal system. Having to give up the right to use her title for personal purposes is a huge loss for her brand. When the deadline expires, the silence that replaced public response suggests that Meghan has been forced to bow to institutional pressure. Now the question is, can she continue to maintain the image she has built, or will she be reshaped by British law? This incident is pushing the relationship between the Sussexes and the British royal family to the brink of unprecedented tension. Will Meghan comply with Parliament's request or resist to the end? Is this just the beginning of a long legal battle? Share your thoughts in the comments section below. Don't forget to like the video, leave a sub to support the channel, and turn on the notification bell so you don't miss the next hot developments. Thank you for watching. See you in the next video.